Why Equity Law is Evil. Reading from AnnaVonReitz.com. I've been asked, why do you attack British equity law so vehemently? Here's the short answer. It's not British, and it's not equity, and it's not law. In the 1750s, a great hue and cry began in England because of the arbitrary and unjust effects of imposing outdated written one-size-fits-all laws without consideration of mitigating circumstances. For example, the sentence for murder is death. But what about unintentional, accidental murder, what we now call manslaughter? And what about murder committed by children by accident or by the mentally incompetent who couldn't possibly know what they were doing? How about murder in self-defense? The young woman being choked by a would-be rapist and thief who finds a loaded gun and fires. Or crimes of passion. The betrayed husband who finds his wife in the arms of another man and snaps. There was a good deal of well-founded discontent with the hoary and draconian common law of England, which had ceased to be determined on a case-by-case basis as intended and devolved, especially in large cities, to a reliance on sentences established by the case law. This over-reliance on the pure written law of record in similar cases, and who is to say what is similar, and the gradual replacement of true jury trial by one's peers to judgment by rule and by whatever jury was summoned, quite often not actual peers of the accused, led to massive controversy about the true nature of justice and the ability of the common law to provide it. Not, I think, coincidental to the times, the BBC is advertising a series called Garrow's Law, which is supposedly based on actual cases tried by William Garrow, a young barrister who stood on the forefront of this entire movement to bring a more considered and considerate justice into the courts, and the development of a system of law that could see beyond the black and white words on a page, clearly stating things like the sentence for murder is death by hanging, no matter what. Sounds wonderful, doesn't it? A better law, a more just law, a more considerate law, a more fair law. But unfortunately, just as the pendulum moved in the 1750s to create the shades of gray we all now know and agree to be just, such as the provisions for manslaughter in juvenile court, the same forward and redeeming motion carried too far in the other direction, muddying the virtuous and sure if sometimes dreadful and puritanical English common law with international admiralty law to create British equity law. The primary proponent of this mocking marriage of English common law with admiralty law was Lord Mansfield, a former Scottish admiralty attorney who rose to favor and crafted the basis of British equity law in the years immediately before the American Revolution. The problem with British equity law is that it allows the judge to sit in place of the king, which displaces the traditional place and power of the jury of one's peers. Suddenly, a barrister is king. He can use, quote, his discretion to inflict the harshest sentence available under the written law, or he can soften the sentence as he sees fit, or dismiss the case entirely, just like the King of England might. Of course, this power is entirely seductive to the members of the Bar Association, and as it turns out, seductive for the king as well as his minions, can use their discretion, seductive to the king as well. His minions can use their discretion to benefit him and his friends and the ruling class in general, and if by chance they go too far in their toady behavior, he, the king, can emerge as the savior from these abuses, his hands immaculately clean. So the idealists who sought to create a more perfect justice than the English common law provided wound up creating something that was more varied, more precise, more mutable, more sophisticated, in the bad sense of the word, but also far more prone to manipulation, abuse, and the currying of favor. Also, it must be said that this new equity law totally violated another safeguard provided to individual people by the honestly executed common law, judgment by one's own peers. England then as now is a culture dominated by culture. A man does not have to speak to be known in England. Who and what he is, his education, his social station is worn like an armband or famously a funny hat. So the tradition of trial by jury of one's peers is a literal reflection of the fact that different strata of society have different standards, different knowledge, and different values. What is justice to a chimney sweep or a fisherman is not necessarily the same as justice of a lord or, and this is my point entirely, a barrister. What one man regards as gross impropriety is commonplace to another. So those of the same social class and profession and nation are unavoidably the peers that can most rightly judge the actions of another of their brethren. And ultimately, this tradition of judgment by peers also yields the most accurate judges of the law itself. By testing a law against all social strata, all professions, all religions, all races, to judge if it is truly fair and right in all their many eyes. When a jury of one's peers is replaced by a judge, the power and purpose of jury nullification is also lost. The common law of England and the common law of America both provide and provided for the additional safeguard of jury nullification. Quite aside from judging the particulars of an individual case, true common law juries can judge the law itself, and if they find it unfair, unreasonable, or unjust, they can throw it out. The legislature does not rule the people it serves, so long as the people have access to the power of jury nullification. This safeguard of the common law prevents oppressive, insane, arbitrary, or unfair laws from standing on the books and plaguing entire generations of people. So from the standpoint of preventing abuse of power by judges exercising their personal discretion for personal or social gain, and from the standpoint of ensuring that people are judged by their peers and not someone alien to the realities of their lives, and from the standpoint of truly refining the law itself, the common law stands superior in every respect, despite the occasions where equity law has provided true equity and justice via the good heart and wisdom of individual judges. With a clear insight now into the ways and means used by the British Territorial United States of America subsidiary to gain secretive control of American land and labor assets, and to also insinuate British equity law on American soil, it is thunderously apparent how equity law has been used to oppress the people and gild the kings, those in Westminster and in Congress. If the object of law is justice and order, then equity law is the open door to feudalism, class strife, cronyism, and ultimately, though not in every case, injustice. Because by adopting British equity law, we adopt coercive power and place it in the hands of one man or woman operating only according to his or her discretion, which ultimately too often means what I can get away with. It also leads to a perverse reward system in which those judges who make the most money for the court get the richest pensions and favors, and who are preened and petted for the choicest professional favors. He who feeds the king, whoever and whatever the king may be, gets fed in return. So in such a system, the natural affinities a man might have for justice too often get set aside in favor of his new vacation home, a college education for his grandson, or a new job promotion for his wife. The justice provided by one man can be bought or sold. It's a question of at what price. Therein lies another potent reason the British equity law fails the cause of justice. It's relatively easy to buy, bully, or kill one man, but the bulwark of thousands of years of common law, that's not so easily swayed. Also, finally, and this is the most telling too, without jury nullification doing its after-the-fact pruning and proving of the legislature's work, laws proliferate like dandelions in spring. It seems to be a universal plague of nature that men who are elected to the legislature think that it is their business to pass laws for other men to live by. And if at least 10 such mandates do not carry their names and approvals each session, they think they aren't doing their jobs. I did a random study here in Alaska some years ago and found that the legislature was passing between 200 and 300 new laws per year. 3,000 new laws, give or take, per decade. What? What? Are we really creating so many brand new point sources of evil and mayhem that it takes 200 to 300 new laws every year to keep things in order? Who's going to learn all these new laws, and who's going to pay for their enforcement? Without the operation of jury nullification operating in the background, these laws just burgeon and accumulate like a cancer growing in the dark. This is why, at last count, the federal government and its agencies were busy trying to enforce 80 million laws. Think about it, seriously, 80 million laws. This is yet another dangerous and undesirable result of adopting British equity law and allowing it to run rampant on our shores. It denies jury nullification and results in this unbridled growth and proliferation of laws that simply stay on the books and appear to breed 10 new volumes every year. Somebody has to pay for enforcing all those laws, and plainly it has already reached the point where any attempt at fair, competent, and universal application of such laws is impossible. Nobody has the ability to know and obey 80 million laws. So they are A, meaningless, or B, arbitrary and sporadically enforced, which gives rise to more injustice and more police incompetence and other social evils and costs too numerous to contemplate. I once estimated that if the current Alaska legislature did nothing but review and repeal laws already on the books, it would take them 10 years to arrive at a reasonable number of laws that could be provided a reasonable amount of enforcement. 10 years of legislative sessions just to clean up the mess that would have been taken care of by jury nullification otherwise. Prone to corruption and difficult to correct is a recipe for failure, no matter what idealistic goals might otherwise be espoused. And all that is quite aside from the fact that the American people are owed the American common law. American common law, unlike its British cousin, didn't suffer the disadvantages of the British equity system. At worst, it was simply elbowed out of the way and left in relative disuse by the quiet, improper proliferation of British courts on our shores. Wrapping up with my first comment, it's not British, it's not equity, and it's not law. British equity law isn't British in the same way that a mixed breed dog is neither this breed nor that. The English common law is what it is, but admiralty law comes from the far corners of the earth, an ancient amalgam that belongs everywhere and nowhere, with roots in the trading practices of Sumeria, Babylon, Egypt, Mycenae, Crete, Africa, India, China. It isn't equitable either. What is equitable about men submitting themselves in trust to another man who is not impartial, not likely to be their peer, and who has a profit motive to share them both? And as for it being law, law is based on timeless religious and ethical principles, not the opinions of individual pet peeves and petty concerns of men caught up in the exercise of their own spleens and the commerce of political power. So no, it's not British, it's not equity, and it most certainly is not law. See this article and over 800 others on Anna's website at annavonreitz.com. To support this work, look for the PayPal button. You spell it ANNAVONREITZ.com. Why incorporating and privatizing government is evil. I'm reading from annavonreitz.com. The main reason that incorporating and privatizing government is evil is that it mixes public and private functions in an inappropriate and ultimately irresponsible way. Think about it for 5 seconds. What is the goal of any private for-profit corporation? To make money. What is the goal of any public non-profit organization supposed to be? To provide service. What do you get when you mix the two? The equivalent of Exxon with a license to sell you any service they want to sell, provide any service they want to provide, and charge you as much as they please for it. It's the ultimate soft racketeering machine, like the old magazine subscription scam on steroids. You order one magazine subscription fair and square. The publisher sends you 3 sample magazines for free, but if you don't promptly and actively say thanks but no thanks, you're on the hook to pay for 3 more magazine subscriptions you never wanted, plus the one you did order. That's how the corporate government has been working too, selling you more and more and more services at their own behest at their own rates, and nobody has been minding the store close enough and acting with enough authority to say a big fat no that is necessary to prevent this from happening. So Tony and George and Sam all get together and decide as your representatives that you want a new prison industry investment to provide you the services of incarcerating more criminals. They charge you for building the new prison facility and staffing it and providing external security for it. They set up contracts with other in-house service providers to profit off the prisoners' labor. And then they set up 80 million statutes so that they can arrest practically anyone for anything. And as a final service, they arrest you, steal the value of your life and labor for a period of years, and charge you heavily for this service too. Gee, isn't it great, all this public service? They quickly and quietly forget who is paying for all this service because they're too busy stuffing their own pockets and padding their cronies' pockets too. You wanted this service, didn't you? Your representatives ordered it and charged it to your room service number. So what's another $600 million boondoggle? What's that, you say? You don't see this as a service to you, especially since the police and prison guards aren't there to protect you and your assets anymore. They're on the take to protect the corporation or corporations leeching off of you instead. But you gave away your proxy to all these yahoos who voted for you. You consented to this. Hey, babe, you kept the extra magazines. You participated in their elections. You sent these guys to Congress to serve in your name. So they get to spend your money on business opportunities for themselves in the name of serving you, and you wind up being served, mostly for lunch. That's the short version of why mixing public service with private greed is a recipe for disaster. The service quickly gets turned around to serve the company, and the astonished people find themselves on the receiving end of humongous, inflated, totally irresponsible bills for service that they don't want, don't need, didn't order, and often can't recognize as services at all. There's nobody left to defend you from these white-collar predators because they're all working for the same company, bent on increasing their profits at any cost, and it's all at your cost. Because these organizations are all incorporated, they just spend your credit to the moon, then seek bankruptcy protection for themselves after offloading their corporate assets to new subsidiaries and naming you as the surety standing good for all this. It's like having Cousin Bubba go on a 3-week bender at the most expensive casino on earth and charging it all to your credit card because you were stupid enough to let him have access to your wallet. There's no real consequence for them. They just go bankrupt with very little left on the table, and like those stores that have endless going out of business, liquidation sales, and keep right on chugging, these guys do the same, all at your expense. What's that you say, Mama? You don't recall ordering any solid gold bathroom faucets? Well, I'm sure it's in the missing Department of Defense itemized budget somewhere. 1 dishonorable man is a disgrace. 2 dishonorable men are a law firm, and 3 or more are a Congress. John Adams. See this article and over 800 others on Anna's website at ANNAVONREITZ.com.